Hey everyone, and welcome to BarTalk, the podcast of the North Carolina State Bar. I'm Peter Bolac, the Assistant Executive Director at the State Bar.
And I'm Brian Oten, Director for Ethics and Special Programs.
And we are here to give you yet another recap of a State Bar Council quarterly meeting. This is the recap of the April 2022 quarterly meeting, in which quite a few things happened.
A lot of stuff happened.
We got a lot of items that to go over today, and some of them that we're just not going to get into the detail that we wish that we could and that these issues merit. And so look for future podcasts to cover some of these other issues that we'll be talking about today. So briefly on the events front from the meeting, we did have a number of events at the April meeting. We had what is probably one of the best events of the year, which is the joint dinner between the State Bar, the Bar Association, and the Chief Justice's Commission on Professionalism.
Right.
We weren't able to do that in January due to that meeting being virtual, so we got together in April. The highlight of that meeting is the presentation of the Chief Justice's Commission's Professionalism Awards. There were a number of awards given this year because they did 2 years worth, and so we would love to congratulate Judge J.C. Cole, Judge Forrest Bridges, attorneys Deborah Foster, Jimbo Perry, and Rich Towers on their awards, and then posthumously the late great David Friedman was also given a Chief Justice Commission award, which meant a lot to us at the State Bar. We thought very highly of David as well.
Absolutely.
So in addition to that dinner, we had another great annual event, which is the 50-year lawyer luncheon, in which lawyers who were admitted 50 years ago were honored, and judges and justices attended that event as President Jordan read the names and the short bios of those 50-year lawyers, which is another great sight to see. And on Friday morning at the State Bar Council meeting, the Chief Justice attended and made remarks, which we're always grateful for. Justice Newby being there for that, continued to impress upon the courts to be open and work on their backlogs. COVID has certainly slowed a lot of courthouses down, and just the need to get that moving so justice can be administered without delay. So we were excited to have the chief there. And now let's go through kind of a recap of what the committees did and what the council did this quarter, Brian. And let's start it out with some of the rule amendments that were worked on.
That's right. We had a lot of activity from a variety of fronts. But one of the biggest things that came out from this quarter were the rule amendments, both amendments to the rules of professional conduct as well as administrative rule amendments, which we're going to get to in just a second. But some of you who are listening to this may remember that last quarter we published some proposed amendments to rules 1.6 and 1.9 in the rules of professional conduct. These amendments dealt with a lawyer's duty of confidentiality with regards to information that's in the public record. Those amendments were published. We received some comments, generally supportive comments. Of course, there were some questions about how they would apply and so forth, but the Ethics Committee took a look at all those comments and ultimately voted to approve the rules and send them on to the council for full adoption. Executive committee agreed, and ultimately the council did vote to adopt those rule amendments to rules 1.6 and 1.9, and they will transmit those amendments to the North Carolina Supreme Court. Just a quick reminder to everybody that any amendment, whether it's an administrative amendment or an amendment to the rules of professional conduct, that has to go through the Supreme Court for final approval. So those will be transmitted to the court, and we'll see what the court has to say. But we also had another amendment to the rules of professional conduct that was proposed. It was discussed, debated, and ultimately voted to be published this quarter. So I would encourage everybody to take a look at that State Bar Journal, go on the State Bar's website, because you're going to see an amendment to Rule 1.19. And some of you may not really be familiar with that rule because it's never really come up in your practice.
Let's hope not.
Right. Rule 1.19 deals with the prohibition on lawyers having sex with their clients. Now, I want to preface all this and say that this proposed amendment is not the product of State Bar staff just being bored and deciding to tinker with the rules.
We're not a bunch of prudes sitting here.
No. But really, this rule amendment is the product of really an unfortunate increase in reports of inappropriate sexual communications between lawyers and clients. So this rule, currently the rule prohibits sexual activity between lawyer and client. This rule amendment expands the scope of the rule to prohibit also sexual communications between a lawyer and client. Now, those of you may kind of hear that right now and think, well, my goodness, that might be very broad, and what exactly is this rule prohibiting? I would encourage you to take a look at the text. This thing was vetted by members of the council that sat on both the grievance committee and the ethics committee. We took a look at a number of different drafts and really tried to craft the language to be sure that we're addressing the conduct, the inappropriate conduct that has been reported to the bar, and in a way that's going to effectively address the situation. So I would encourage you all to take a look at that rule. If you have comments on the rule, you think it's good, you think it's bad, you just want to say, I can't believe you actually have to put this in writing, feel free to send your comments at ethicscomments@ncbar.gov. Every single comment, all the feedback submitted will be considered by the ethics committee and the full council.
And if you're going to send those comments in, don't attach any inappropriate pictures to it.
Right. No emojis.
If you're wondering,
either.
the idea is that what this rule is about. Think text messages in which people send something that nobody wants to see.
Right. Yeah, unsolicited sorts of communications that's just inappropriate. Of course, the rule would really only prohibit those types of communication in the lawyer-client relationship. So, I guess theoretically somebody could send something totally inappropriate to us and they're not violating the rule. But I would still encourage you not to do that, please.
Yeah, because remember, everything that comes to the bar is public record unless there's an exception.
Right. So with that said, moving on, let's talk about the other big rule amendment that was proposed. Peter, this is your territory because there are some sweeping changes proposed for the continuing legal education program of the North Carolina State Bar.
Yeah, this is a big one, guys. This is going to be something that we have a separate podcast to really go over in detail. But after a multi-year study, the CLE board has proposed some pretty massive changes to the CLE rules and how lawyers are going to have to stay compliant with CLE in North Carolina. Some of the biggest changes, just as a quick list, are the increasing of the reporting period from 1 to 3 years. So instead of 12 hours in 1 year, lawyers are going to have 3 years to do 36 hours. We think this gives lawyers more flexibility to take courses at their own pace. Certainly also it eases some administrative burden on the CLE staff if we stagger it in a way that there's only 1/3 of lawyers who are due every year. The elimination of the annual report requirement. Another good benefit we think for lawyers is that if our system it says a lawyer is compliant with their CLE, then why do they have to submit a form to say that the system is right? So we think this will allow the focus to be on those who are not complying, and instead of dinging lawyers who are a couple days late clicking a button or submitting a form. Changing the fee structure from attendance fees that are per hour that nobody likes to have to pay, these little $12 to $15 invoices from the state bar every year, to an annual attendance fee that would be paid in your dues renewal period. You'd pay a one-time fee every year, and sponsors would pay a course application fee instead of having hours-based attendance fees.
I think it's important to note that annual fee is, at least right now, it's thought to be, it will be less than what lawyers normally pay when they have to pay all, $350 for 12 hours.
That's right. Some lawyers might not realize it because they pay it as part of their registration for a course, but every hour that a lawyer takes is assessed a $3.50 charge at the moment. And so the ABA, when they look at what the cost of practice is for any particular lawyer, they count in North Carolina $42 because it's 12 times $350. What the CLE board is likely going to propose as an annual fee is something like $25. So this would be a reduction in that, and we'd hope that sponsors would also show a equal reduction in their cost since they're not covering those attendance fees for every lawyer. One of the trade-offs that is going to come with the increased reporting period is the elimination of the grace period for lawyers. And and also the elimination of the carryover credit. And so, some lawyers who want to build up all those hours so they are always a year ahead. Well, now you have 3 years to do your hours, so we don't need to have that build up anymore.
Or you have 2 weeks to do 3 years worth of CLE.
Well, there's going to be some lawyers that wait and then realize that they have to do 36 hours in February. But
I'm just asking for a friend, just so we're clear.
We're just trying to give everybody the freedom and liberty to make their own choices and try not to have to protect you from yourselves. In doing this, we hope to be able to increase the enforcement on those who are not staying compliant, but giving more freedom and flexibility to those who always do remain compliant. We're going to have a lot more information on the CLE rules in another podcast, and I'll be out promoting these rules to various organizations and on videos and with some virtual meetings where people can ask questions while they are in the publication period here over the next 3 months. So, Brian, in addition to the rule amendments, we also had 3 ethics opinions published and 1 ethics opinion adopted. If you'll just quickly go through those, and then we'll break a couple of those down.
Right. So 1 opinion was adopted. This is an opinion that was published after the January meeting, 2022 FEO1, which deals with an attorney who is appointed both as a guardian ad litem and as the attorney advocate. If that affects your practice area, I would encourage you to take a look at that particular opinion as we try to offer some guidance and really address the different conflicts of interest that come up in that particular situation. But the ethics committee had a robust discussion this past quarter and ultimately published 3 different opinions, 3 new opinions, and really want to talk about 2 of them. The first one is proposed 2022 FEO2, which deals with limited representation in a criminal matter.
Yeah, so Brian, this is an interesting one. We gather some reports and hearing from people across the state who are practicing. A lawyer might want to step in and represent a client on a particular portion of their matter, of their criminal matter, but maybe doesn't want to take on the whole case. How does a lawyer do this, especially if that client is represented by an appointed counsel?
Right. And this was something that I have to say was an interesting topic, not just because of the ethics issues involved, but because we heard different responses from different parts of the state as far as how their county has reacted to that. Some counties reacted very poorly to a lawyer stepping in and trying to do limited representation, particularly say represent somebody only in a bond hearing, while the criminal defendant had already been appointed, somebody from the public defender's office. Other parts of the state thought this was great because it actually alleviated some of the work and the stress that the public defenders were facing. So we were trying to find a balance, and ultimately this opinion really kind of tries to advise folks that, hey, if you're going to engage in this type of limited representation, the rules do allow it, but limited representation is only permissible if it's reasonable under the circumstances. And the opinion kind of talks about what those circumstances are, what a lawyer should consider in determining whether or not they can actually step in this very limited fashion, particularly when you're dealing with an indigent client, and perhaps the ramifications of your limited representation and being retained privately for a very limited purpose. In some counties and different parts of the state, we heard that some judges would look at that and say, well, you're no longer indigent because you retained somebody, whereas some other counties were not really looking at it that closely. So ultimately, I think it's a good opinion to just kind of offer some guidance for what seems to be a kind of a common situation and really an increasing situation in criminal representation. Again, if you have some sort of thoughts on this opinion, we'd love to hear it. ethicscomments@ncbar.gov.
And Brian, I admit to being naive to this, and I'm sure some people might have the question, in North Carolina, is there a requirement that a lawyer has to, make a motion to withdraw from the case if they come in limited representation? Right. Is the lawyer potentially going to get stuck in there?
Right, and and that's something we discussed a fair amount in the subcommittee. This is where we have a bit of a difference between criminal and civil representation. Civil, you've got that general rule of practice that says you can't get out unless the court lets you out. right? You have to file that motion to withdraw and get the court's permission to actually withdraw. Criminal, there is a statute out there. It's in 15A that does allow limited representation as long as that's been communicated to the court that essentially you are stepping in as the attorney for this defendant in a limited fashion. And really the statute contemplates that if you have fulfilled your responsibilities in that limited fashion, you can withdraw without the court's permission. Otherwise, there is still a requirement to get court permission in other contexts in a criminal representation, but criminal does have a little bit of an exception there that makes it different from civil litigation. So that's where this opinion, again, tries to offer some guidance to lawyers that might want to engage in this particular type of representation.
Yeah, I really encourage you to check this out if this is an area in which you might find yourself at some point. These proposed rules will be in the journal, or the proposed opinions will be in the journal and online, and we'll try to get these out in other ways as well. Brian, let me set the scene up for this other opinion that we're going to chat about. In addition to there was Formal Ethics Opinion 3, which is a very narrow opinion related, not necessarily related to the full bar that lawyers are probably going to want to take a look at, but Formal Ethics Opinion 4 is one I want to spend a little bit of time on, which is billing considerations for overlapping legal services. So let me set the stage and ask you this question. So let's say that I'm representing a client in which I have to fly out to Chicago to take a deposition, and in my agreement with the client is that the client's got to pay for my travel time. So the client's going to be paying $150 an hour for the time that I have to travel to Chicago for this deposition. But I'm sitting on my flight, and I've got this time, and this plane has free Wi-Fi, and I've got a chance to do some work. And so I knock out three hours for a different client on that flight. When it comes time to bill these hours, can I collect from both client A for my travel time and for the 3 hours that maybe I did for client B?
That is a fantastic question, and it's one that I think the bar as a whole had a very common answer of, no, you can't do that for a long time. But it seems that question or the answer being no has been called into question recently. The ultimate answer from this opinion is no, you can't. The reason is that really when you are billing your client, you need to provide an honest accounting of your time. So if you are really doing work for two different clients, you're increasing your efficiency in providing legal services. That efficiency is not something that you, the lawyer, can use to benefit your bank account. Instead, the efficiency needs to be passed on to your client. So in that particular situation, my advice would be that you need to figure out a way that kind of accounts for the proper proportion of work that you've done. In that situation, I might suggest something like splitting the fee, halving the fee for the travel time for client A and halving the fee for the legal work that you've completed for client B. But ultimately, if you build, let's say, you're on that flight for 3 hours and you've done 3 hours of travel and 2 hours of work, you can't bill 5 hours of work to have occurred in 3 actual hours. That would be false. It'd be misleading. And so that's where the opinion sets out clearly that is something that's not permitted by the rules, both in terms of charging a clearly excessive fee, making false or misleading statements about your services, or just engaging in dishonest conduct. And I have to add that this opinion and this conclusion is something that really is shared across the board in other jurisdictions. The ABA opined on this back in, I believe it was 1993, and a number of other jurisdictions have joined in that particular conclusion. The state bar here has advised folks you can't do that for a very long time. But like I said, there's been kind of an increase in question about this, and maybe even some pushback on the reasoning here. So the Ethics Committee wanted to make a definitive statement of what a lawyer can and cannot charge, and really particularly to say that any efficiency that you create by being able to accomplish work for both clients or multiple clients at once needs to be passed on to the client.
Well, and it makes sense that there's a a new question about this as technology's advanced in a way to
Right.
let you do multiple things at the same time. Is this going to be the same situation if I'm having to go to calendar call on Monday for 3 or 4 different clients, and I'm billing them, for each hour that I have to sit at calendar call? How do I deal with the fact that I've got 4 clients and I can't bill them all, right, for all day that I'm sitting at calendar call?
That's correct. If you're dealing with you've got 4 different clients that you're appearing at court for during calendar call, and all 4 get called within that first hour, you spend 60 minutes at that or in that courtroom. You cannot bill 4 hours of work for each of those clients. You would have to essentially quarter that 1 hour. Again, it needs to be an honest accounting of the work that you've completed. You've done an hour's worth of work, not 4 hours worth of work in 1 hour. And so because you've created that efficiency by appearing on behalf of 4 different individuals, that efficiency needs to be passed on to the clients.
Is it fair to say, Brian, there's really no situation in which you should be able to bill more work than the actual hours of the day?
I think that's fair to say, yes.
Okay, well, that's an easy rule to follow.
Right.
Again, check out these opinions. I think that I would hope that you would agree with these opinions. They make a lot of logical sense to me, but you might disagree, and I think that the Ethics Committee would be very interested in hearing your opinions about this and any comments you guys might have. Again, that email address for those comments, Brian, is
ethicscomments@ncbar.gov.
All right. So that takes us out of the ethics opinion area and the ethics process. We'll get back and give you the scoop on the random audit for the quarter here at the end to make you wait for it a little bit. But let's talk about the Issues Committee, which was another place in which we had a lot of action this quarter. Again, probably more than what we can cover in this podcast, and so maybe we can get some additional podcasts or additional information out. The biggest, the item that had the most action this quarter in the Issues Committee was actions taken from recommendations of the Diversity and Inclusion Subcommittee. And there were a number of recommendations from that subcommittee which had been meeting for well over a year. And we'll just kind of summarize these very quickly. Brian, there was a diversity statement that the Issues Committee and subsequently the Executive Committee and the Council agreed to.
That's right, and the statement is one that will be published in the State Bar Journal, will be put on the State Bar's website. Something that again was crafted by the subcommittee, but also the content was really formed by the entire council in this process, and so would encourage everybody to take a look at that. And
this committee had some great debate and really took these matters seriously, and there were some close votes in some areas, and most areas also were ended up being unanimous. In addition to the statement, there was action to incorporate diversity education into the State Bar Council's orientation, analyze the State Bar's kind of internal policies as it relates to DEI. Making sure that we have opportunities at all levels here in North Carolina, especially here on staff and in the council. Demographic questions, maybe it's time for us to start collecting some demographic information to allow us to make sure that, we are inclusive and that we are acting without bias here at the bar. Recognizing some Juneteenth and other state holidays, not necessarily as paid time off, but as recognition of other state holidays, making sure that everyone has access to the State Bar's resources and public protection programs, whether that's different types of languages or disabilities, to be able to access our resources. And then I've got to tell you guys,
something unprecedented happened.
Unprecedented. It's probably the first time that this has ever happened. I've read the minutes of the bar for a long time and have never seen this come up. And it's really, it was just one of those perfect moments of awkwardness and and then that led to some comedy. And so there was one of the recommendations was was just to continue the work of the subcommittee. There was some discussion on how we would do that, and certainly some disagreement on how this would all work, and some other suggestions. And so by the time that the vote got called, I don't think anybody had any clue where they wanted to go on it. And so there was a vote vote in favor, no votes. And there was a vote against the motion, no votes. And so the motion, the recommendation failed for lack of getting a majority. And
Yes.
it was just
Just a
something
0-0
special.
vote. I've never seen that at the state bar. And
A bunch of lawyers in the room with opinions, and we couldn't get a single vote on either side.
right.
So it was, and then finally there was a recommendation to look at the history of the state bar, the full history of the bar, warts and all, good and bad, and try to come up with some sort of written history of the bar and figuring out how to get that funding so we're not necessarily using lawyer dues to do that history.
That's right.
Brian, there was at least we ran out of time, but we started to talk a little bit about the regulatory change recommendations.
Right, and this has been pending for a while now, and it's going to continue into July, or at the July 2022 council meeting. But the subcommittee that was appointed to study regulatory change issued its report to the Issues Committee back in January, and like Peter said, we were trying to talk about it at the April meeting, but simply ran out of time. There was a little bit of discussion, and the chair of that subcommittee, Mark Enriquez, attorney from Charlotte,
Noted podcast host.
noted podcast host, but he presented the report, but had to do it in a rather hurried way because we were running out of time. And I think it was very clear, based upon the discussion that ensued, that additional conversation needed to be had about these very complex issues surrounding access to justice and regulatory change, namely, how we regulate the bar. And the big question being, are the current regulations inhibiting lawyers from evolving their practice and potentially, of course, then inhibiting the ability of the public to access legal services in a meaningful way? So we're going to continue talking about that at the July meeting. Hopefully we'll have an update for you all after that meeting.
Thank you, Brian. Let's wrap this up with the details you've all been waiting for. The Grievance Committee met, and here are the results. The Grievance Committee met this quarter and dismissed 115 files. They continued 4 files. They referred 1 lawyer to the Lawyer Assistance Program. They referred 3 lawyers to the Trust Accounting Compliance Program. They issued 12 letters of warning, 4 admonitions. Those are private discipline. They issued 4 reprimands and 1 censure, both public written discipline, and then referred 9 cases to the Disciplinary Hearing Commission for trial on whether potential suspension or disbarment of that lawyer.
That's right. And we have some random audit information.
Yeah, wrap us up with some of where are we going this quarter?
So this next quarter, the judicial district selected for the random audit, District 8, composed of Edgecombe, Nash, and Wilson counties, and District 28, composed of Montgomery and Stanley counties. So if you are listening to this podcast and you are a member of those local judicial districts, you may be hearing from the State Bar's random auditor this next quarter.
Well, that's going to do it for yet another great quarter here at the North Carolina State Bar. Again, we handled a lot of items this quarter. The council is going to be getting together in July to do it all again, and after that meeting, Brian and I will be back here to recap it for you. Look for some podcasts in the interim to go over the CLE rules and potentially cover some other items that we didn't have time to get into a lot of detail on here today. And we hope you'll tune in again and keep joining us here on BarTalk.